Hi, it's Mike DelSignore. I'm here to talk about a case called Commonwealth versus Edward Long, and this case may have a major impact in helping us move towards racial justice and racial equality under the law. And the reason is the case deals with the issue of what happens when a minority or Black American is profiled by the police when they make a traffic stop. And this happens every day. But it's very difficult to prove. And what our Massachusetts Supreme Court in the Edward Long case is going to hopefully do is come up with a standard that makes this idea of equal protection under the law meaningful. Right now, it's a mark that can't be hit. In other words, Massachusetts Supreme Court decided a case called Commonwealth versus Lora that set forth the test. And recently, when the Massachusetts Supreme Court heard oral arguments in the Edward Long case, it was acknowledged that no one has ever proved an equal protection violation under this Lora standard. And I want to explain why I think the law is made it difficult for individuals to prove a claim of racial bias or racial motive in a traffic stop. So the United States Supreme Court decided a case in 1996, Commonwealth versus Wren. And in this case, the United States Supreme Court held that subjective motivations basically don't play any role under the Fourth Amendment. So under the Fourth Amendment, if someone's stopped and the officer's real reason is a racial bias, as long as you have a neutral traffic infraction, as long as the officer could say, well, he was speeding, his headlight was out, there was some kind of traffic violation, then the motive why the officer decided to make the stop is irrelevant. And what happened is these claims of a racial bias or profiling had to be litigated under the Equal Protection Clause. And the reason why that is significant is because it's very difficult to make an equal protection claim. You need a statistician, you need data. And the Long case brings out the practical reality that these claims are hard to prove, but we see a history of profiling. So what happened in the Long case is the defendant was pulled over for an inspection sticker. There's a motion to suppress hearing. And at that motion to suppress hearing, the officer acknowledged, well, I've written 6 citations out of 1,000. So the officer acknowledged that he didn't care about the inspection sticker, that the real purpose, this officer was from the gang unit, was really to stop the person, see what was going on, see if there was drugs in the car, see if there was a reason to search the car, reason to get the person out of the car. It wasn't because of the civil infraction. And the statistical evidence that the defense lawyer presented in this case was convincing. They had a statistician. The minorities made up 40% of the population, and they were stopped at about an 82% rate. So the statistical evidence was very significant and called out for some explanation. So what happened at the motion hearing, the Superior Court judge in Suffolk County found that the statistical evidence wasn't good enough. The case went to the Massachusetts Supreme Court. The Massachusetts Supreme Court actually took the case prior to Mr. Long having to go to trial. So they took the case, sort of expedited it, and showed sort of special interest in the case. Normally someone has to lose at trial and then you appeal. The idea being that if the person wins the trial, then the appeal would have been unnecessary. So usually on a motion to suppress, when it's denied against a defendant, that has to be litigated after the case. But so the case goes to the Massachusetts Supreme Court, and the court seemed very concerned that this data is not available. In other words, the court made clear, all the justices seem to agree that the defendant in this case used the best available data around. And the issue is, well, what happens if the data isn't available? And I think the court's going to say that when they create a standard for this, and I think the court's going to sort of redefine how a defendant proves an equal protection violation, is if the data isn't available or isn't kept, it's going to go against the Commonwealth. So the defendant in this case presented all the best available data and proved a significant statistical disparity. So the issue is, well, what does the government do? How can they rebut this? And the court's going to decide what happens at the next stage. And this is from the case of Commonwealth versus Lora, the original case that set forth the equal protection standard in Massachusetts. but no one's ever really litigated stage 2 because stage 1 has been such a high bar. So I think the court's going to say stage 1, what you initially have to show to force the government to show a race-neutral reason for a stop, is a reachable standard, that if you use the best available data, if you present compelling statistics, even if there are other statistics, if those statistics can be relied on, and we can't have the court say, well, the statistics weren't good enough, when it's the government's job, the police department, they're keeping the statistics. They're the ones that have access to this information. So I think, one, this case is going to be a landmark case in one respect, because I think the Massachusetts Supreme Court will require police departments to keep statistical data of their stops so that this can be a meaningful right. So second, hopefully the court will go far further than that and say that you can litigate, and that the Fourth Amendment does recognize that the Fourth Amendment is violated when there's a racial bias for a traffic stop. Some other states have what they call a but-for test. If the stop wouldn't have made but-for race, it should be a violation of someone's Fourth Amendment rights to be free of unreasonable search and seizure. The Fourth Amendment protects unreasonable searches and seizures, and when you stop for no other reason but your ethnicity or your race, that should be a Fourth Amendment violation. So frankly, it would be I think the court at minimum is going to redefine and require police departments in Massachusetts to keep statistical data, but hopefully they go a step further and say that it's even easier to prove. We don't even need statistics if we can show that the stop wouldn't have been made but for the race of the person. Then that's a violation of the Fourth Amendment. So there's two sort of legal theories where the court can create a meaningful right to have equal treatment under the law and to sort of eliminate racial profiling in traffic stops. It's one, the Fourth Amendment, two, the Equal Protection Clause. And I think the court was concerned when I listened to the oral argument in the case. The Chief Justice of the Massachusetts Supreme Court said, let's kind of create a standard, give us a standard that a reasonable defendant with reasonable means can meet that burden. So one problem with requiring all the statistical data is it's costly, it's expensive, and you don't. The court seemed to recognize you don't want to create a right that practically no one can ever reach, and that's why I think this case is going to be important. It could be followed hopefully by other states in creating equal justice under the law by giving true meaning and giving practical ability for a defendant to show racial profiling and have the case dismissed. And now when that happens, that should change behavior. That's the goal of Fourth Amendment violations. Whenever someone stopped, there was obviously a gun in the car in the case of Long. There's always going to be some criminal activity, otherwise the police would have let the person go. But it's through the government losing this ability to prosecute, losing this evidence that they'll change behavior and we'll have new standards and we'll have equal and fair treatment under the law. So that would be the goal here, and I think this case will have an important impact because one reason we have a problem with race in this country is because there's a perception that the police are not treating people equally, and I think a case like this would go a long way to eliminate that. If you'd like to talk further, I'm Michael DelSignore. I'd be happy to talk about the Long case and any of its implications. Feel free to contact me. My cell phone number is 781-686-5924.